The name of this video is Don't Accidentally Commit a Crime. The reason I'm doing this video is because I have spoken to a number of individuals who call me up because they've got a traffic citation and they need representation so it doesn't go on their driving record or just help. And the more we talk, we realize that, or rather, I help them to realize that they're actually being accused of breaking the law and committing a crime, not just a traffic ticket. So to start off with, there's about 4 different categories that you can find yourself involved in if you have to go to court. One is going to be you're being accused of an infraction. That can either be traffic or non-traffic. Now, infractions are your lowest level. They just typically deal with a fine, no jail time, nothing along those lines. Second is going to be your simple misdemeanors, punishable by up to 90 days in jail and a $1,000 fine. Then you've got gross misdemeanors, punishable by up to 364 days in jail and a $5,000 fine. And then you got all your felonies. Those penalties can range quite at different levels. What we're looking at today are 2 common occurrences where people believe they might be infractions, but they're actually violations of the criminal code. They can find yourself in court and much more serious violations. So the first is going to be your hit and runs. Most people, when they think of the crime of hit and run, they're envisioning a car accident, hitting an individual, something along those lines where it's fairly dramatic in fashion and somebody ends up leaving and not staying on the scene rather. It can be a lot less than that though and still qualify as a criminal law violation. Backing up in a grocery store and slightly colliding with the vehicle behind you, just a little fender bender, or even just a little ding, and then driving off, that's considered a hit and run. Anytime you've come in contact with another vehicle and there's been any minute damage, that triggers the RCW for hit and run, which requires you to leave your name and your address on the vehicle or in a conspicuous area on the vehicle, or find the owner. Those are your qualifications in order to not break the law in that situation. But like I said, that's even for minor tapping of a vehicle. In fact, most people have seen this happen in a grocery store where the person just slightly bumps and then they leave. Technically, that's a violation of the law and they can find themselves in court for that. The second is going to be reckless driving. That one is a little bit more amorphous. And what I mean by that is the statute says driving in a willful and wanton disregard for the safety of persons or property. There's a lot of things that we see on the road every day that would say, well, that person's being reckless. Bobbing and weaving in and out of traffic, not using their blinker as they're doing that creates a dangerous situation. Those are your more obvious circumstances. What's a little less obvious is you can actually be accused of reckless driving anytime you're exceeding the speed limit. Now in practice, you're not going to get accused of reckless driving if you're only doing 5 miles over the speed limit and not putting anybody in danger. However, most offices, if you are going 20 miles over the speed limit, they see that as a prima facie case, which means the baseline to charge you with reckless driving. So be aware, anytime you're going 20 miles or more over the speed limit, you're in danger of being charged with reckless driving. Now, that's not to say you can't be charged by going less, you absolutely can, but that seems to be a common benchmark that a lot of prosecutors' offices look at. So, if you're accused of any of these crimes, give me a call, or if you have any questions, leave some comments below. I'd be happy to answer them. Have a good day.